The National Service Scheme is a central sector scheme of the Government of India by the Ministry of Youth Affairs and Sports. The NSS unit of NLU Assam was established in June 2020, and since then it has held various events, seminars, and webinars on a spectrum of themes and volunteered programs on diverse social and cultural concerns. National Legal Services Day is observed every year in India on 9th November to spread awareness for ensuring reasonably fair and justice procedure for all citizens. It was spread by the Supreme Court of India in 1995. The aim of celebrating this day is to offer free of charge, proficient, and legal services to the people belonging to weaker sections of society. It also seeks to make sure availability of free services to weaker section people, as well as making them conscious about their rights. I would now like to request Dr. Deepthimoni Boruha Ma'am, Associate Professor and Chairman of Center for Clinical Legal Education and Legal Aid Cell at National Law University and Judicial Academy, Assam, to commence the session with a welcome speech.
Thank you, Vishka. Good afternoon, one and all present to this session. Honorable Mr. Justice and Kotishwar, Sir, Judge Gauhati High Court and Executive Chairperson of the Assam State Legal Service Authority. Honorable Vice Chancellor of National Law University, Assam, Professor V.K. Ahuja, Sir. Respected Registrar, Dr. Indra Das, Academic Registrar, Dr. Nandradani Chaudhary, respected participants and dear students. It is my pleasure to welcome everyone to this significant event. On behalf of National Law University, Assam, I extend cordial welcome to chief guest of this session, Mr. Justice N. Kotishwar, sir, to this significant occasion. Lordship, your gracious presence is highly appreciable by all of us. I also extend hearty welcome to all the other participants to this event. The philosophy of the Constitution of India is to meet the justice, social, economic, and political. But after 75 years of independence, this constitutional commitment remained as a luxury instrument in the hand of the elite group of people in the country, because a large group of people encountering, that is poverty, economic deprivation, shocking social injustice, and the official authority continuously denied from availing justice under the Constitution of India. Considering the seriousness of this problem, the Government of India, 1987, enacted the Legal Service Authorities Act to facilitate the free legal services to the needy people of the country. Since 1995, 9th November is celebrating as the Legal Service Day to mark the people to make our people about the various provision of the Constitution and this particular legislation and the rights of the citizens. The aim of celebrating the day is to offer free and efficient legal services to the people belonging to the weaker section of the society, also spread the awareness among the students and the children about their constitutional rights and law relating to them. But overwhelming majority of the general population of the country not utilizing the legal aid services because of the lack of awareness and poor quality of the legal aid services in the country. Therefore, good quality, better standard, better level of the legal aid must be ensured to make the people have the faith in the legal aid system in the country. People must know and have the faith that the effective and efficient legal justice mechanism is present in the country to assess justice. Therefore, this is not only the duty of the government, but we also try to spread awareness among the people how assess justice through the free legal aid services in the country, and with these objectives, the National Law University Assam organizing today's event to spread the awareness about the free legal aid services in the country. we are very grateful to have with us the chairperson of the State Legal Service Authority, the Honorable Mr. Justice N.K. Singh sir, who has the better idea and who can give the better picture the existing free legal aid services and mechanism existed in the country. Once again, I welcome all of you and take this opportunity to thank all of you for joining with us. I hope to enjoy this day by all of us. Thank you very much.
Thank you, ma'am, for your kind words. Our Honorable Vice Chancellor, Professor Dr. V.K. Ahuja, is a renowned academician and has provided constant support to the NSS unit in all its endeavors. Sir has motivated each one of us to give the best to the society and the nation at large. I would now request our Honorable Vice Chancellor, Professor Dr. V.K. Ahuja, to kindly address the audience with his enlightening words.
Thank you, Rishika. Honorable Mr. Justice Kotishwar Singh, Judge Gauhati High Court and Executive Chairman, Assam State Legal Services Authority, my dear colleagues, teachers from other institutions, Registrar Dr. Indranushi Das, students, ladies and gentlemen, a very good afternoon. NALSA, that is National Legal Services Authority, was constituted under the Legal Services Authorities Act 1987 to provide free legal services to the weaker sections of the society and to organize law adalats for amicable settlement of disputes. Friends, we are now celebrating Azadi Ka Amrit Mahotsav in the 75th year of our independence. It is really painful and a matter of concern for all of us that till date, justice remains a distant dream for millions of people who are from downtrodden and marginalized section of the society. The government has taken an initiative by establishing NALSA at the central level and State Legal Services Authority in every state to achieve the objective of providing legal aid to all these people. The students of law schools and law universities, apart from others, are being made paralegal volunteers, PLVs, where the PLV training is being given to them by the State Legal Services Authority. And the purpose is to assist the District Legal Services Authority to reach out to the community at grassroots level to understand their problem, to make them aware of their legal rights, and to take up their legal issues. Friends, at Delhi University, from where I come, where I was heading my law center, I found some mixed reaction from the people who were the beneficiary of this particular scheme. Today we have with us Lordship, and he will correct me if I'm wrong. Now, if you look at the urban areas, the cities, you'll find that the efforts of the government and the efforts of NALSA or State Legal Services Authority are visible to a certain extent. But the reaction, as I told you, has been a mixed reaction. People in the slums of the cities are being made aware of their rights, and they also approach the advocates who are on the panel of the State's Legal Services Authority. Not only that, they have the understanding, some sort of understanding, that every law school and the universities have got legal aid clinic, and they approach there also, and they get guidance from there also. Friends, the satisfaction level of these people have not been very good, as many of them have complained, and this is what came to my notice also. And what they say is that these free advocates are not that good. I do not know what exactly is their notion, but one thing is clear, and which even I have also realized, that maybe that the advocates who are on the panel of these legal services authorities are not doing what is expected of them. Friends, we need to think about it, and the legal services should not only mean the doing service just for the sake of doing service or helping people, but it means providing quality legal services. And we have to ensure that the panel advocates of these state legal services authorities do their work honestly and effectively. As far as the remote areas are concerned, the villages are concerned, lot of efforts are being made, but I think we need to do lot many things to reach out to them, to make them aware of their rights, to tell them how they can be beneficiary of this legal services. Well, today we have with us Honorable Mr. Justice Kotishwar Singh, the Honorable Judge of Gauhati High Court and the Executive Chairman of Assam State Legal Services Authority. In my couple of interaction with the Honorable Lordship, I found him to be an excellent human being also, who is very much concerned about the marginalized people. And we had some interactions, and I shared some viewpoint with respect to the community outreach program. And I was very happy to see that the Lordship was very receptive, and he immediately responded positively and assured me of providing all institutional support to the students of National Law University Assam at the time when we take up the community outreach program. I'll meet Lordship. This is what I suggested with sir, and of course we have to think about it. We have devised some modules, etc., and I'll be seeking the help of Lordship, as to how we can do our best at the community level. Friends, you should, it is mainly for the students. They should think, this society is doing a lot of things for them. And the education, wherever they are getting, if it is the education in the central universities or traditional state universities, it comes almost for nil, and the entire education is subsidized. In NLUs, of course, they pay the fee, but still the government is helping a lot to run the institutions. So in any case, all these students, they owe a lot to this society. And they have to ensure that, once they come to a particular level, they have to give back to the society. And what I feel is that though fortunately or unfortunately, legal education has been taken out of the national education policy of 2020. But what I feel is that the Bar Council of India should ensure, and not only the BCI, but every regulatory authority, and in all courses, the universities must ensure that it should be mandatory for every student, whether he is from humanities, whether he is from sciences, social sciences, law, or from any other discipline, that it will be mandatory for them to do community outreach program before they are conferred with the degree. So on behalf of National Law University Assam, I welcome Honorable Lordship, who is going to address us on the topic of free legal aid to beneficiaries, a significant step towards access to justice on the occasion of this pious day, that is the National Legal Services Day, when the government has taken the initiative of reaching out to the poor people and providing them legal aid so that they could also get justice. With these words, I welcome one and all who have joined today. Thank you very much. Namaskar.
Thank you, sir, for your words of wisdom. Now, I would like to introduce to you all our Honorable Chief Guest, Mr. Justice N. Kotishwar Singh. His Lordship is presently a judge of Gauhati High Court and the Executive Chairman of Assam State Legal Services Authority. He is the former judge of Manipur High Court and has also served as acting Chief Justice of Manipur High Court. His Lordship has completed his schooling from Ramakrishna Mission Vidyapeeth, Purulia, West Bengal, and pre-university course in science from St. Anthony's College, Shillong. Graduated from Kirori Mar College, Delhi University with BA Honours in Political Science in 1983. He obtained his law degree from Campus Law Center, Delhi University in 1986 and enrolled as an advocate in the same year. He has also attended the 6 months Commonwealth Young Lawyers course under the University of London in 1992. After a brief practice in the Supreme Court of India, His Lordship shifted practice under the Gauhati High Court, the then Common High Court of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, and Arunachal Pradesh. He has also practiced in the Central Administrative Tribunal, Gauhati, and the subordinate courts in Manipur, and was the standing counsel for various government departments, Government of Manipur, and public undertakings, and appeared before a number of commissions in Manipur, constituted under the Commission of Inquiry Act 1952. His Lordship has practiced in the World Congress of Justice for Children from 28th to 30th May in 2018 at UNESCO, Paris, and was the part of the 8 Justices team to attend workshop on counter-terrorism Phase 2 training held at Washington, D.C. and Orange County, California from 10th to 14th September in 2018. The NSS unit of National Law University is honored to be graced by your presence, Your Lordship. It is my great privilege to request our Honorable Chief Guest, Mr. Justice N. Kotishwar Singh, to enlighten the audience with your words of wisdom and address them.
Thank you, and very good afternoon to everybody present today through this virtual mode. Present here, I can see Professor V.K. Ahuja, Vice Chancellor of the National Law University and Judicial Academy, Assam, Dr. Dipti Moni Barua, Chairperson of the Center for Clinical Legal Education and Legal Aid Sale, Naluja, Registrar of the University, and other faculty members, and my dear friends, all students of law. Every year on this day of 9th November, we celebrate to commemorate the enactment of the Legal Service Authorities Act 1987. Law, in the broadest sense of the term, as we students of law understand, is something which pervades our lives from the day we are born till we depart from this world. In fact, I would venture to say that it starts even before we are conceived. I'll just give a few examples. The relationship between a man and woman before a person is born will decide whether the offspring will be treated as a legitimate or illegitimate one, having consequences for the offspring. The Medical Termination of Pregnancy Act 1971 will decide when the life of an embryo or an unborn child will be extinguished. Law in India permits abortion up to 24 weeks of pregnancy, as we all know. Thus, we see that throughout our lives, we are governed by different laws in our all spheres. Even death will not part us from law. Law of succession will decide how the legacies are to be determined. A dead person is entitled to a descent last right. Thus, living or dead, law hovers around a person with all its omnipresence. In India today, there are about 1,250 laws. Even most of us who are in the legal fraternity and well acquainted with laws, various aspects of law, are not aware of many of these existing 1,250 odd laws. And these laws define the rights and duties in our day-to-day existence and day-to-day lives. Yet, many of us are oblivious of these laws. Though we all know that ignorance of law is no excuse in a court of law, unfortunately, the reality is that millions of our co-citizens are ignorant of these laws. In the process, they are most of the time at the receiving end of their lives, either due to self-induced circumstances or over which they have no control or situations foisted upon them. In addition to these statutes, there are hundreds of welfare schemes implemented by the central government as well as the state governments. But many of these intended beneficiaries are not aware of the benefits. And even if they are aware, are ignorant how to proceed, how to apply, how to get these benefits. What is the consequence? The consequence is that they are not able to enjoy the full rights and privileges granted by the law and the constitution. As we all know, our constitution embodies the solemn promise made to ourselves at the beginning of our republic after gaining independence to secure what? To secure to all its citizens justice, social, economic and political, liberty of thought expression, belief, faith and worship, equality of status and opportunity, and to promote among them fraternity, assuring the dignity of the individual and unity and integrity of the nation as contained in our preamble. I just would like to share while I speak some of the PPTs. How do I share this? Share. No problem. Is the slides visible?
Yes, Lordship.
Okay. Now, just referring to these preambular principles, I mean, I think as students of law, we must keep these principles in mind. That is a very beginning of any person who is involved with law. I mean, of course, this is not particularly meant only for lawyers and law students. It's for entire country, for everybody, every citizen. But we who are in the field of law must be at least fully aware of the implications, significance of these preambular principles, which will all throughout life guide us. As I mentioned also, that because of this ignorance, these ideals, they remain a mere mirage, far away from the reality. What is the reason? India has a population about 138 crores, which is equivalent to about 17.7 of the total world's population, and is ranked number 2 in the list of countries, the most populous country. In the global hunger index, as per 2021, India ranks unfortunately at 101 position out of 116. Not a very bad and not a very, happy state of affair. Similarly, India is home to 1 in every 3 illiterate person in the world, with 34% of the illiterate population of the world. This is a big challenge. These are the areas, these are the issues, the problems we as a country, one of the largest democratic country, has to deal with. Therefore, in the midst of this ignorance, deprivation and poverty, can these people really get justice, enjoy the liberty, equality, and lead a dignified life as promised to ourselves? They certainly can also enjoy these rights. They certainly can enjoy this freedom and justice if appropriate assistance is rendered to them. Thus, it is the significance of this legal service authority and the legal aid, the concept of legal aid. Legal aid, as we understand today, appears to be of a recent origin. As students of law, we are immediately, our attention is drawn to Article 39A of the Constitution, which was inserted in 1976, or the Legal Service Authorities Act 1997, of which we are discussing, or the formation of Committee on Legal Aid and Legal Service Advice in Bombay 1949, and various other recommendations made by the Law Commission of India. These concepts have been there already. However, one can trace this concept in ancient times also. Under the Roman law, the praetor or the governor used to appoint advocates in proceeding to represent minors, physically or mentally retarded individuals. And they would render the service without any remuneration on the ground that such an appointment was considered to be a public duty. In Middle Ages also we see this phenomenon practice. The assistance was provided with what was known as advocate for the poor, advocatus pauperum. Of course, in the modern world today, in a society governed by rule of law, it is considered to be an integrate and inseparable part of the legal system. And we are familiar with the word pro bono, with which legal aid is closely associated. Pro bono is the abbreviation for the Latin phrase pro bono publico, which translates as for the public good. One of the examples as students of law we come across the first case in which an advocate, Pushpa Kapila Hingorani, filed a case in 1979, which later on became the famous Husainara Khatun versus State of Bihar. It was a writ petition filed, it was a habeas corpus petition filed before the Honorable Supreme Court under Article 32 for release of 17 under trial prisoners whose names cropped up in an article published in a newspaper in Bihar. Taking cognizance of that, the Supreme Court, referring to Article 39A of the Constitution, observed, this is a very important observation, and that's why I just like to reiterate it. What Honorable Supreme Court said is that this article also emphasizes that free legal service is an unalienable element of reasonable, fair, and just procedure, for without it, a person suffering from economic or other disabilities would be deprived of the opportunity for securing justice. The right to free legal services is therefore clearly an essential ingredient of reasonable, fair, and just procedure for a person accused of an offense, and it must be held implicit in the guarantee of Article 21. This is a constitutional right of every accused person who is unable to engage a lawyer and secure legal services on account of reasons such as poverty, indigence, or incommunicado situation, and the state is under mandate to provide a lawyer to an accused person in the circumstances, if the circumstances of the case and the needs of justice so require, provided, of course, the accused person does not object to the provision of such lawyer. So with these ideas, with this philosophy, with these ideals as enshrined in the Constitution, the Honorable Supreme Court directed release of these persons. And Honorable Supreme Court directed that whenever any under trial who is charged of an bailable offences is produced before the magistrate, the state government should provide them with a lawyer at his own cost for the purpose of making an application for bail. As we all know, this principle was reiterated in a subsequent case of another famous case, Khatri versus State of Bihar in 1981. This case again was a very unfortunate case involving the blinding, what we in Bhagalpur, what was infamously known as Bhagalpur blinding case, where 31 prisoners were arrested by the police, were blinded by pouring acid in their eyes. And many of these, except for 2 or 3 persons, remain unrepresented by lawyers, and they were languishing in jail for a long period of time. And this Honorable Supreme Court, following the earlier decision in Husainara Khatun, directed the release of these prisoners. And in this case, the Supreme Court also rejected the plea of the state of Bihar that they said that, well, if we have to provide free legal aid to so many people, we don't have the means, we don't have the financial resources. Supreme Court said no. In that connection, Justice Bhagwati quoted Justice Blakeman in Jackson versus Bishop. Human considerations and constitutional requirements are not in this day to be measured by dollar considerations. And accordingly, the Honorable Supreme Court observed that it is elementary that jeopardy to his personal liberty arises as soon as a person is arrested and produced before a magistrate. For it is at that stage that he gets the first opportunity to apply for bail and obtain his release, as also to resist remand to police or jail custody. That is the stage at which an accused person needs competent legal advice and representation. And in this case, Khatri's case, the Supreme Court emphasized the constitutional obligation to provide free legal services to an indigent accused, and mentioned that it does not really start when the trial commences, but from the very beginning, as soon as he is arrested and produced before the magistrate. They're very important landmark judgments which continue to shape our legal aid philosophy, the jurisprudence of legal aid in this country. This whole pro bono is so important that today the Supreme Court has made it a part of any lawyer who desires to be designated a senior lawyer must show that he had done certain pro bono work. That was emphasized in Indira Jai Singh versus Supreme Court of India, where Honorable Supreme Court laid down the guidelines as to how a senior designation is to be conferred to a lawyer. There is a specific marks provided for the lawyers who had done pro bono work. So I just wanted to say that this pro bono work, which is an essential element of the legal aid, is a very important aspect which we must be fully acquainted with. But legal aid is not confined to only pro bono works. Now it has been institutionalized with the enactment of this Legal Service Authorities Act 1987. Therefore, all of us who are involved in the legal aid institutions essentially act as a felicitator or a bridge between those intended beneficiaries, the deprived section of the society, with the benefits conferred under the statutes or under the various schemes. Though most of the students are aware of the provisions of the Legal Service Authority, I felt that I must emphasize upon certain important which have been reiterated by the speakers before me in introductory remarks, in the welcome speech, that legal services is not only meant to be free, but also qualitative service. Therefore, in the preamble itself, we find that it is an act to constitute legal service authority to provide free and competent legal services. Very important. It is not merely our idea or desire, but it's a mandate of law. If we fail to provide competent legal service, we are not really providing the legal service which is needed by the needy persons, which we find reiterated in the preamble. I would like to briefly also touch upon the structure of the Legal Service Authority. As we all know, we have at the apex what we call NALSA, National Legal Service Authority. The Patron-in-Chief is the Honorable Chief Justice of India, and Executive Chairperson is the second senior most judge of the Supreme Court. They lay down all these policy decisions. And at the state level, we carry out these various policy decisions through our district legal service authorities. So every state has to have a state legal service authority, of which the Patron-in-Chief is, of course, the Honorable Chief Justice of the High Court. An executive chairperson will undertake all the works, which generally is the senior most judge of the High Court. Though it is not necessary as per the Act, it says the sitting judge or even a retired judge can act. But sitting judge has his own advantage because then the coordination is much more effective. And because of these advantages and coordination, the level of coordination, also effective implementation, it was felt that senior judges should be heading this state legal service authority. And of course, and one of the senior most judge of the district judiciary is made a member secretary of the state legal service authority. Under the state legal service, we have district legal service authorities, of which the chairperson is again the district and session judge, because he is the one who would know the affairs, the functioning of the legal infrastructure, the legal requirements in this district. But this is a body where the DCs, the deputy commissioner, or SPs are also members. The public prosecutor is also a member, and other social workers. Now, then there is also another what we call taluka level also, because there are some apart from the district, there are some talukas. There is a provision in Assam. We have 35 district legal service authorities, and 2 are taluka level at the taluka, what we call taluka legal service committees. So these are the briefly kind of structure by which the legal aid, the legal services is being provided in the state. As I mentioned, what are the key functions of legal services? I will not go much in detail, as you have seen in the Act also statute. It is to provide, essentially to provide legal aid to persons who are entitled, which is provided under Section 12 of the Act, and also encourage settlement of dispute by negotiation, arbitration, and conciliation. Then carry out legal literacy campaign. That's why the students would come into, and the role of students become very important. Then to conduct lok adalats, to organize, to undertake research, organize training in the field of legal services, to create legal awareness about the rights, benefits, and privileges of the weaker section of society. So these are big, broad, where, in my opinion, is also now the desire of the NALSA that the students should be involved more in these activities, of which I shall be referring. Now, who are those persons who are entitled? We must have some these basic ideas. All of you have ideas. A member of the scheduled caste, scheduled tribe, or victim in human trafficking, beggar, a woman or child, a person with disability, a victim of mass disaster, natural calamity, ethnic violence, etc., industrial workman, person in custody, whether a minor or major, then those who are belong to the poor section of society having less than 3 lakhs of income in case of Assam. So these are broad kind of categories of persons who are entitled to the legal aid. Now I come to specifically for the students. Now Section 4K of the Legal Service Authority Act 1987 specifically provides that the Legal Service Authority is to develop, in consultation with the Bar Council of India, programs for clinical legal education and promote guidance and supervise the establishment and working of legal services clinics in universities, law colleges, and other institutions. What are the objects? To improve the clinical legal skills of the students, and also to inculcate an attitude amongst the students to provide effective legal service to the poor and marginalized people. So these are very important part. Therefore, students have become a very important part of our entire regime of legal services. I would like to go a little bit detail of how the involvement is necessary. There's already a structure in place, what is called National Legal Services Authority Legal Services Clinic in universities, law colleges, and other institutions scheme 2013. What are the objects of this scheme? As I mentioned here also, to set up a nationwide collegiate legal service clinics to familiarize the law students of the country to the problem faced by the masses ignorant about their rights and remedies under the law, to make them aware, to educate them. Then secondly, to bring out, to reach out to the marginal and vulnerable communities through these clinics, and to spread legal awareness through aware campaigns, camps, seminars, debates, legal counseling, posters making, street plays, to expose students to community service, to introduce the student to socio-economic impediments to access of justice, to provide the students a platform for the empowerment of the socially, economically backward groups. So you are an enabler. You will act as enabler, the students, through this platform of the Legal Service Authority. I'll just go a little bit, also refer to some of the regulations, 21 to 26, in what are 20 of this, which provides that section 20, regulation 21, the legal aid clinics to be run by law students. The emphasis is given on the final year students and other junior students to assist them. And there will be faculty members, of course, in this. It is also given in our chart that the District Legal Service Authority will render all necessary assistance to the legal aid clinic. In fact, we are supposed to render some financial assistance also. Now, what are the scheme? What the students are expected to do? You are expected to reach out to these remote areas, organize camps, make them aware, as mentioned earlier. These are very important functions of this legal aid clinics, of the law colleges. Then they conduct surveys, prepare reports. They are supposed to be permanent legal aid clinics. Now we have these paralegal volunteers. As we can understand, we as judges and lawyers who are involved in these legal service authorities, we have limited resources, both financial as well as human resources. Now, to carry out this huge mandate, huge task, very important, but yet very huge, as we can understand from, that is why I mentioned about the gravity of the problem, the population, the ignorance, the poverty, the level of poverty of the people. Now, because of this enormity of tasks, it will be difficult to reach out without the help of certain volunteers. Therefore, what we call paralegal volunteers. They are, of course, paid some remuneration, 500 rupees per day, and they act volunteers, all kind of, and they can be anybody. They can be law students, but of course, as students, we can understand you have commitments to your academic requirements. Therefore, you will not be able to spare so much of available time with us. But nevertheless, we'll train the students in this work, how to reach out, how to carry out these functions. In that context, the paralegal volunteers will be, service of paralegal will be available to locally, how these legal aid activities have to be carried out. I would say, unfortunately, that perhaps because of the COVID situation and perhaps lack of coordination, I take the blame to myself also to some extent, being the nodal authority for implementation of this legal aid clinic, that in most of these law colleges, the legal aid clinics, though have been open, have not been as effective, functional to the extent we would expect. As I mentioned also, because the COVID situation and earlier lack of coordination also perhaps, therefore we have taken a decision, and as mentioned by the VC also, that we are trying to organize in a much more comprehensive, systematic manner, how to reach out, how to utilize the services, valuable services which the students can render in the field of legal services, in the field of legal aid. As students, we all know you are sincere, you are energetic, you are young, you are enthusiastic. That is perhaps one of the greatest attribute of a volunteer. Because unless you are imbibed with these values, you are imbibed with these ideals, unless you are enthusiastic, you are energetic, it will be difficult, because who are the ones we are going to reach out? They are the ones who are, as mentioned, disposes the weaker section, marginalized section, who have no hopes in their eyes. So therefore, it is not going to be an easy task. But in the process, we are going to empower them. And in the process, we are going to, as students, we are going to hone our concept, hone our ideas of what justice really means. It is through this practice, through rendering legal aid, we will understand the real meaning of the theoretical definition of justice which we have been studying in our courses. Because the theories doesn't mean anything if it cannot be translated in practical benefit for those people who really are seeking justice. In that context, I would again mention that this, yes, if in all these activities, the role of the students is enormous, in fact. And in the last point, you can see, if in the course of their activities at the legal service clinic, as provided under clause 6 of the scheme, students identify issues that affect large groups of people, they may file social justice litigation, what we call PIL, public interest litigation, in the name of the legal service clinic with approval of the concerned legal service institution. Therefore, it is provided under the rules and the regulations that the students can file public interest litigation petitions before the court. If you are able to identify those areas which affect large groups of people, it gives you an opportunity to be part of the function of the justice delivery system in this country. Mr. Professor Ahuja, he himself has been from Law University, Delhi University. And when I was a student of law, 82, 3, I think I remember, we had gone to this children home, juvenile home. At that time, 87, this act was not there. And JGB Act also, I mean, this juvenile justice, this act also not fully not fully operational, all at the kind of a very kind of in a very formative stage, not yet crystallized into the specific statutory provisions. We could see how when we visited this children home, how we felt, how we wanted to help these people, and in fact we were guided by our teachers to work for them, trying to interact with them, trying to find out their problems, reach out to their relatives. At that time, of course, there was no mobile. Therefore, it was difficult. Communication was also difficult. But today, if the students can visit all these children, children home, observation home, child care institution, even jail also, you can do wonders. You can act as a kind of facilitator and a media to reach out to their family members. These are services which have to be offered pro bono, as I mentioned. These are services of which we cannot expect any remuneration as such. Of course, as institution, we'll try to provide certain financial support, but there cannot be a kind of a paid service for this. It has to be all voluntary. These are very important areas where the students can play. In fact, most of you know Professor Menon when he was speaking in the National Legal Aid Conference in 2011 in West Bengal, National University of Judicial Science, Kolkata. He was mentioning our incident when they came across a lady was trying to find out the location of her husband who had gone to Delhi to lobby for transfer to his home place, but he never returned, and she had no clue what had happened to her husband. Somehow, the students they met some law students, and they went to Tihar jail with the help of his family members, identified him, and the consent courts was moved for grant of bail. So these are small things. It makes a lot of difference for a common man. And just recent also, you have heard of this Shreya Singhal case in a very landmark judgment. Shreya Singhal was a student, who filed this petition, led to the striking down of this Section 66A of the Constitution of the Information Technology Act. We also know this last week, one girl student of class 8 from Telangana, belonging to a village in Rangareddy district, wrote to the Honorable Chief Justice of India, complaining against the disruption or discontinuation of the bus service. I think the schools and the college, all the important institutions were located about 18 kilometers away. Therefore, all these villages, including the students, were dependent on this bus service, which was discontinued. And she wrote a letter. And of course, the office of the Honorable CGI sent a copy of the letter to the director, managing director of the corporation. Then they immediately restored the bus service. These are some examples where students who are imbibed with these ideas, and understand the problems, can certainly take part in many of these activities which can help the weaker sections of the society. Therefore, I will not take much of your time. I just want to emphasize, again, I will request for the students to get more involved, as mentioned by Professor Ahuja, that under the new education policy, legal literacy perhaps is no more given an importance. But contrary to it, in our last meeting held in the last month, the National Legal Service Authority, of which I am also a member, we have taken a decision to involve the law colleges through the Bar Council of India. In fact, we have collected all the names of all the law colleges in the country. We are going to reach out to the law colleges with the help of Bar Council of India, so that the students can get involved in a much more. In fact, I'm very happy to also say that in the last Lok Adalat we had organized quite a number of students. Those students were involved, and I would say that, of course, many law colleges, because of lack of coordination, could not participate. But I'm sure in the next hour, this ongoing process of law color and other programs, we would like the students to get more involved. It will give them an opportunity not only to serve, but to see from a close quarter how our judicial system, our justice delivery system works at a grassroots level. We always normally were always watching what is happening in the Supreme Court of India and High Courts, but we hardly have an idea how this judiciary functions at the district level, at the taluka level, at the subdivisional level, where the common man, where the poor people come in direct contact with the law, where the people are arrested, they are produced. So all this direct brush, actually, the direct contact with law, how law operates. It is not very, a pleasant situation to be in the court of law. But nevertheless, as students of law, if we are able to understand how it functions, those future lawyers and judges can perhaps, in my view, can discharge their duties in a much, productive manner. If you are able to understand the problems that our legal system functions, I would say that as far as the role of the students concerned, it is a huge potential for the law students, because, as I mentioned also, there is a huge gap in the justice delivery system as far as particularly referring to these weaker sections of society. Therefore, there is huge potential for law students to contribute in a much more meaningful manner to the deserving people. With these few words, I would like to thank all the law students with appeal that they involve themselves more with the activities of the legal services, and there is already a platform available, and I'm sure with all the dedicated faculty members there, you will get a wonderful guidance. And as we are again assuring you that from our legal service authorities, We will be sending our judges also, not only lawyers, serving judges at the district level to explain to you how it functions, and we'll request this law student also visit our other, not only your legal aid clinic, but other clinics which are being operated by us in hospitals, in jails, in gram panchayats, and various front offices where we are doing our activities. You can come and contribute, even if for a few hours. Well, wonderful. That will be good for us also, because your presence, your participation also will certainly strengthen the movement. It is not only purely of lawyers and judges only, but the entire citizenry who have certain sense of duty towards a society, of which the students, I am sure, can play a very important role. Thank you very much for.
Thank you, Your Lordship, for your kind words. I would now request our Honorable Program Head of NSS Unit of NLU Assam, Professor Mr. Himanshu Ranshan Nath Sir, Assistant Professor, National Law University and Judicial Academy, Assam, to kindly express the vote of thanks.
Yeah, thank you, Ruchika. The chief guest of today's event, Honorable Mr. Justice and Kotishwar Singh Sir, Honorable Vice Chancellor, National Law University and Judicial Academy, Assam, Professor V.K. Ahuja Sir, the Registrar of University, Dr. Indranand Siddhas, SES, my esteemed faculty colleagues of the National Law University and Judicial Academy, Assam, and my dear students and distinguished attendees of this webinar lecture from across the country. So, as Lordship has already stated that the legal service is a is the need of the hour, because law depends. I mean, law is everywhere, and law regulates us in everyday basis. Like earlier, there was a connotation that science is everywhere. So law is also everywhere. From starting from our day with the help of law, and then till we go to bed, there is law everywhere. And most importantly, that ignorance of law is not an excuse in India, in our country, and like all other common law legal system. So, but say for example, one do not understand the nitty-gritty of science, medicine, or astrology, or cooking, say for example driving. So it hardly matters. But if we do not know law, then it may bring trouble to us. And therefore it is very important to have such kind of illuminating conversation and lectures. So at the outset, I would like to thank for the illuminating and encouraging and very informative speech of Lordship. So big thank you from NSS unit and the National Law University and Judicial Academy, Assam, to Lordship, Mr. Justice N. Kotishwar Singh Sir. I would also like to thank on behalf of the NSS unit to our patron, the Vice Chancellor of the National Law University and Judicial Academy, Assam, Professor V.K. Ahuja Sir, for his encouraging and his pressing interest in keeping the NSS very active. I would also like to extend my vote of thanks to the distinguished faculty members who are present here, the honorable attendees, my dear student friends, the volunteers of NSS, Professor Devashish Poddar sir, who is sitting here next to us, our honorable registrar and academic registrar, Dr. Nandrani Madam. And I would fail in my duty if I do not extend my sincere vote of thanks from the NSS unit to the IT team of the university and the IT operator and system administrator for their support in conducting this lecture. So with this, I would like to call it a day. Thank you, Your Lordship, for joining us.
Thank you. Thank you very much.
Thank you, Lordship.
Thank you.
Thank you.
Hey there, please stop the recording now. Please stop the recording and end the meet. Then only the recording will be saved.